But the Supreme Court, Georgia Supreme Court, did reject the petition, and it's all about how he didn't go to the Superior Court first. And it's pretty detailed in that, I mean, they kind of give him a roadmap for going back to the Superior Court. And because in his petition that was filed, it was saying there's no point in filing this in the Superior Court because it would go to Judge Glanville, and Judge Glanville is where writs go to die. But this is saying the order says, actually, no, that's not true. It wouldn't go to Glanville. Here, I'll let's see if I can pull it up here. Yeah, see, it says another Superior Court judge will be appointed to hear and determine the matter, and the final decision may be appealed to the appropriate appellate court for review. So they're saying they're a last step here, and basically go to the Superior Court first. So my understanding is that's what's going on. It says here, this is the order again. It says in his emergency motion, Kendrick, that's Diamante Kendrick, Yak Gotti, one of Young Thug's co-defendants who Doug Weinstein represents. It says Kendrick does not seek appellate review of the order denying his motion to recuse. Instead, he seeks original relief from this court against Chief Judge Glanville, asserting that any effort to file a petition for writ of mandamus in Superior Court would, quote, would result in frustration and lack of action because such a petition would go to Chief Judge Glanville. And so he has no option other than the Georgia Supreme Court to exercise its discretion and consider his claims. And basically they say, no, actually not so. It says, by way of relief, Kendrick's requests that this court direct Chief Judge Glanville to adhere to Georgia Uniform Superior Court Rule 25.3 and assign his motion to recuse to an unbiased judge for a hearing, that the court stay the trial proceeding pending resolution of the motion to recuse. This is everything that they ask for in the petition. And that the court ordered Chief Judge Glanville to produce an unredacted transcript of the secret ex parte proceeding held on June 12th, 2024. Although this court has the power to grant original relief in the nature of mandamus, it has chosen to maintain its general status as an appellate court. So they're basically saying, well, we could do that, we're not going to. And that kind of makes sense to take an action like that against Glanville is pretty major. So obviously they want to make sure the whole entire process is being followed. I think it makes sense that, and they say that it wouldn't actually go to Glanville if it was filed in Superior Court. So we'll see about that. But so yeah, says if Kendrick were to file a mandamus petition in Superior Court naming Chief Judge Glanville as the respondent, Chief Judge Glanville would be disqualified from presiding over the matter, and that means just that motion. He wouldn't be assigned it. A different judge would consider Kendrick's petition, and either party may appeal the final decision. So that's why they reject it. And it seems like it seems like, I don't think this is like a huge blow to it's certainly not a ruling on the merits of the petition. And it's interesting just that it's such a detailed order too. They didn't just say denied. I mean, I wasn't really sure what to expect here, but they kind of wrote a roadmap for how to go over this. And they actually, when they include the footnote describing what 25.3 actually is, they actually highlighted the specific portion that, Weinstein is seeking relief on and saying that Glanville violated. So I don't know what to read into that, but I had noticed that in the petition, because it cites Glanville's own 7-page order that he issued that kind of seems to write himself into a corner on it. Like he didn't seem to think it over very well, but he actually, in the order that Glanville wrote rejecting the recusal motion, says that their allegations are sufficient on their face, but he doesn't feel there's enough evidence to support it. And of course, the argument in the petition is that, well, there's no evidence because, well, they're not even at the evidentiary stage yet. He's not supposed to be considering the actual evidence. He's just supposed to be looking at the allegations on their face. But then the argument is the reason they didn't have supporting evidence for that is because they don't have the transcript, because he hasn't released that yet. So let me see if I can pull up the actual order that Glanville wrote, the 7-page order. Because like I said, he seemed to, I mean, he makes it hard for anyone to just kind of reject this on its face and say, no, the petition is not legally sufficient to even warrant going to another judge, because, like I said, he even says in the in his order that the allegations are basically sufficient on their face. So it's like, okay, he seems to be kind of misreading this statute. Like I said, he may have kind of screwed himself in his own order here, but let me pull up his order. Hope everybody's doing good here. Happy Friday. Now here's the actual order from Here's the actual order that Glanville wrote. There's something in here. Here. It's right here. And this is what the petition actually quotes. It says here, the court finds that a cursory review of the Weinstein affidavit submitted by plaintiffs in support of their motion contains assertions of facts to support the allegations of bias and impartiality. And I think by the reading of 25.3, the rule about how these recusal motions get decided, it ends there. The discussion ends there. This means that he has to send it to another judge, because he's supposed to assume that the facts, the assertions in there are true. And this is not the evidentiary stage yet. But then he goes on to say, however, while these assertions were made to support the defendant's allegations against Judge Glanville, there is a notable lack of evidence to support the assertion. And of course, one answer to that is, well, the reason there's no evidence is because they don't have the transcript yet. But really the answer and the legal answer to that is it doesn't matter. It's not time to bring forth evidence. This isn't an evidentiary hearing, and that's not the basis that there's not a standard for him when reviewing this to look at, well, do you have evidence to support your claims? That's the next step when actually looking at the merits of the motion, and not just assuming all the pleadings are true. So I guess when I read this, I'm like, I think he might have kind of screwed himself here, because this doesn't mean that he's going to be recused, but like I said, it makes it hard for anyone else to see this and think that this recusal motion shouldn't have been sent to another judge. So what could happen is another judge could look at all this petition that I don't think has been quite filed yet, but I think it's going to be filed today or Monday, and say that it does need to be considered by another judge. But then what could happen is it could be considered by another judge, and another judge could not recuse him. So again, what I see somebody asking, what happened, and what happened is the Georgia Supreme Court rejected the petition yesterday. Basically said that they need to go to the Superior Court first, Fulton County Superior Court, and that's my understanding is they're in the process of doing that, refining the petition, and they're going to file it in Superior Court. So there's nothing actually pending right now, but there could be. But again, this is the order right here that was issued yesterday from the court, rejecting the petition. But basically, it's not rejecting it on the merits of it at all. It's saying it's saying you basically just need to go to the Superior Court first. So there's definitely still a chance for it. And yeah, Doug was saying that he might be able to, or he said he should be able to join us. I haven't seen him yet, but we'll just keep talking. I think they're kind of busy in there. So the question is, like I said, I think the wording of his order makes it hard for another judge to look at it and say that it shouldn't have gone to another judge for consideration. But the question after that is, once it goes to another judge for consideration, is the other judge actually going to recuse him? And I kind of wonder about that, especially, I don't know if anybody watched there was a bunch of the co-defendants who aren't on trial had their cases severed. We're in court today for possible plea deal acceptance, and none of them accepted any plea deals, but they were talking about cases being severed, because that is like one real insane factor here, is how many of the co-defendants had their cases severed, like during jury selection. So they're just in jail indefinitely right now, waiting for this trial to be over so they can go on trial themselves, and we do this trial all over again. That's kind of crazy to think about. But somebody challenged the severance. The severance was talking about how he wanted the judge to review it today, and the judge's reaction to it, I'm like, oh God, if they get this judge to consider the Glanville stuff, I think you're kind of screwed, because that's the idea. The idea that any of those judges are much better than him. I'm like, I'm not sure, but I don't know. We got to wait to see what happens on Monday with the actual transcript. There's a lot of rumors going around, but the judge has discretion like that to decide on different issues, and we'll see it. And one of the biggest things is, I mean, it's not like Woody is up there testifying incriminatingly. I mean, yeah, they got him on the stand, but he's not testifying the way they want him to testify. So I think in the end, if this ever gets to a judgment within, however many months, and there is an appeal, I think the actual ex parte is going to be seen as it's not going to be the biggest issue in the appeal. And if he does release a transcript and they're able to cross-examine him on it, and it turns out that Woody really did not even say much incriminating against any of them, I mean, I don't think it's going to be seen as some kind of big reversible error. I bet the big appellate argument will actually hang on another issue, because I think there's still a possibility that all this could kind of be cleaned up, because again, it's like, okay, yeah, I mean, Glanville seems pretty confident that he's going to survive this, and that the transcript and what actually happened in that hearing doesn't quite match the allegations of, you coerced him to testify, that kind of thing. And the idea that a judge could actually do that. He's definitely not worried about it. I just think in the big picture that there are bigger legal issues that are going to actually come up here, but we'll see what actually happens with the recusal petition when it gets filed in Superior Court. Because it would be a pretty big blow to his ego if this did get sent out to another judge. Like I said, I think it's a whole nother step after that, whether another judge actually recuses him, but just the act of it being sent out to another judge would be big. And see, I don't think there's any reason to say that he changed the transcript or anything, because again, if they were actually coercing him to testify, I mean, yeah, they got him on the stand, but he's not saying anything incriminating. So I don't know. It'll be interesting to see what actually happened in there. But it is interesting, and I see this in the internet kind of masses to these cases, and you see it in that Karen, whatever the lady who's accused of killing her cop boyfriend or something, which that's just been totally sensationalized. But the tendency of people to just think the absolute worst of people. Like, you can't just disagree with somebody and think that they're making bad decisions. You have to question their credibility and like say that they belong in prison and must be taking like bribes and being paid off when there's like actually really no evidence to like support that at all. You're just, you just have to question people's character instead of questioning like their actions. It's just, I don't know, it's kind of a turnoff to me. But see, I've kind of said in the beginning that I don't think Glanville's not leaving the case, guys. Like right now, the big question is this recusal motion even going to be sent out to another judge for consideration? And normally I would just say no, but when you actually read the order in the law, like I said, he kind of screwed himself over in this, because like he basically wrote in here that it should be granted, it should be sent to another judge. But after that, the idea that he's actually going to be recused, I doubt it. But I'm also not completely familiar with all the politics of the Fulton County Superior Court. Maybe there's some judges there that actually would do it if it came to them. I think there's only like 28 judges total in Fulton County Superior Court. There's like hundreds in LA, but